This is the Daily Brief, one landmark court decision explained in plain English every day. Presented by FindCourtCases.com, this is your daily briefing on the law that shapes American life.
Let's forget the historical dates for just a moment, and let's start with the stakes. Imagine a full-blown constitutional crisis playing out over just 15 frantic days back in 1971. I mean, this was a period so tense it really felt like the United States government was fighting a war against its own press.
It's an incredible scene. On one side, you have the entire weight of the executive branch. We're talking the president, the attorney general, the whole national security apparatus. And then in the other corner, two giants of American journalism, the New York Times and the Washington Post, and they're armed with basically one thing, the First Amendment.
Right. And the government was demanding a court-ordered stop, a total padlock on any more publications. Their claim was that these documents held state secrets, defense plans, and that if they got out, it would cause grave and irreparable harm to the nation.
Yes, they were essentially arguing that the government's need for secrecy completely outweighed this foundational right to a free press.
So if the government had actually won that argument, what would that have meant?
Oh, the power dynamic in America would have been permanently shifted. I mean, it would have given the executive branch this sweeping, unchecked power to muzzle any story it didn't like. All they would have to do is say the magic words, national security.
But they lost.
They lost, big time.
The press won this stunning legal victory. The injunctions were tossed out, and the full story of how the U.S. managed the Vietnam War, decades of it, the embarrassing parts, all of it, was finally laid bare for the public to see.
And the real loser in all of this, the government's claim to absolute unquestionable secrecy, it was shattered.
And that's our mission for this deep dive.
Exactly. That outcome was decided in the Supreme Court case, New York Times Country, United States. And we are going to unpack the legal principle that was cemented there. It's this idea of the heavy burden, and you'll see why it remains at the absolute center of every modern debate about government leaks and transparency today.
Fascinating. So, okay, let's start with the material itself. What exactly was in these papers that was so explosive it pushed the president to sue the nation's biggest newspapers?
Well, the official title was The History of U.S. Decision-Making Process on Vietnam Policy.
Catchy.
Right. Everyone immediately just called them the Pentagon Papers.
And this wasn't just like a memo or two. When you say history, what are we talking about in terms of scope?
We mean a monumental internal review. It was commissioned by the Secretary of Defense, Robert McNamara. We're talking about 47 volumes.
47?
Yeah. Something around 7,000 pages of deeply classified analysis, internal memos, all about U.S. policy in Vietnam up through 1968.
Wow.
And here's the really critical part. These papers showed, in the government's own words, that multiple administrations had basically routinely misled Congress and the American public, misled them about the goals of the war, the progress of the war, for years.
So this wasn't just a leak. This was the unauthorized release of the government's own, deeply critical internal report card.
Exactly.
So the conflict really ignites in June of 71. The New York Times gets these documents
from a man named Daniel Ellsberg. He was a military analyst who had actually worked on the report. He leaks them to the press.
And the Times starts publishing. What happens then?
The government immediately hits them with a legal injunction. So the Washington Post steps in, gets its own copy of the documents, and starts publishing too. It becomes this incredible showdown.
And the government's reaction? You said it was aggressive.
Oh, immediate and highly aggressive.
Yeah.
But here's the key. They didn't go after Ellsberg right away, the leaker.
Okay.
No, they went straight to federal court seeking what are called prior restraints.
Prior restraints. Okay, that's the core legal idea here, isn't it?
It's everything.
So let's break that down. They weren't trying to punish the newspapers after they published something.
No.
They were trying to get a judge to legally stop the printing presses from even rolling, to prevent the information from ever reaching the public in the first place.
You've got it. It's censorship before the fact, and constitutionally, that is the most explosive thing you can do.
Give us an analogy.
Okay, think of it this way. It's the difference between being punished for something you said versus having the government lock you up because they think you might say something dangerous in the future.
Right. And the whole point of the First Amendment is to prevent that kind of preemptive suppression.
Almost entirely, yes.
So how did the government even begin to justify this? I mean, what was their legal argument?
Their argument was that the damage to national security would be so certain, so imminent, and so devastating that it It trumped the First Amendment. It was a pure emergency argument.
But what's so interesting is that at first, in the lower courts, the government lost.
They did. Both the federal court in New York and one in D.C. denied the government's request.
Why?
Because they ruled the government had failed to carry the required, and here's that phrase again, the heavy burden.
The heavy burden.
That phrase is everything. And because the lower court said that, the whole dispute just rocketed, at incredible speed, straight up to the Supreme Court.
So the one clear, one-sentence takeaway from this whole thing, what is it?
I'd say it's this. If the government wants to stop a newspaper from publishing something, it must provide a heavy, clearly demonstrated showing that publication would directly and immediately cause grave and irreparable harm to national security.
And that's a really high bar.
It's an almost impossibly high bar, and that's what separates the U.S. approach from so many other countries. You have to prove, beyond a shadow of a doubt, that a catastrophe is imminent and certain.
Okay, so let's get into the court's reasoning. Why was that bar set so high? The government obviously thought it had a winning hand here. Why did their arguments just fall flat with the justices?
Well, the court overwhelmingly sided with this idea that the press plays a vital role in a democracy.
Yeah.
They weren't just protecting a newspaper, they were protecting the whole mechanism of public information. The foundational principle, which Justice Hugo Black wrote about so famously, is that the press serves the governed, not the governors.
To govern, not the governors.
Right. The whole point of the First Amendment is to make sure the public gets the information it needs to judge what its government is doing, especially when it comes to war.
But the government's lawyers stood up and said, this is classified. This endangers lives. Why wasn't that enough to convince them?
Because saying something is classified is just. It's an internal bureaucratic decision. It's the president saying, I want this to be secret.
It's not a legal argument.
It's not legal proof.
Yeah.
The government failed, really spectacularly, to provide the court with concrete evidence. They couldn't show that publishing these historical papers would lead to the certain death of an agent or the definite collapse of an operation.
So the court was essentially saying, look, we get that this is sensitive, but being afraid of embarrassment or, policy disruption, that's not the same as a catastrophic threat.
Precisely.
Yeah.
And what's more, the court also pointed out what we call a statutory gap, meaning there was no specific law from Congress that gave the courts the power to issue these kinds of injunctions just based on a national security claim. In fact, Congress had actually considered and rejected proposals to give the president that kind of sweeping power.
That's a huge point. So it wasn't just that the government failed to bring enough evidence.
Right.
They arguably didn't even have a law on the books that authorized what they were asking for in the first place.
Exactly. That procedural point just reinforced the whole decision. But the core of it, the real outcome, was that the heavy burden of proof had not been met.
It was a massive victory for press freedom. But we should be clear, this is still controversial, right? People still argue about this.
Oh, absolutely. And reasonable people can disagree. Critics at the time, and even now, argue the court was a bit too cavalier with real security risks.
They felt the bar was set so high, it basically gives the press a free pass to publish anything short of, real-time troop movements.
And it's important to remember, the court did not say that a prior restraint is never possible. That door is still theoretically open.
But only for something that is a literal, provable, existential threat to the country.
Exactly. And they just ruled that the Pentagon Papers, for all their sensitivity, didn't meet that bar.
So let's talk about the immediate fallout. The Supreme Court rules on June 30th, 1971, just 2 weeks after this all started. What happened the next day?
The injunctions were vacated, the stays were lifted, and the newspapers were allowed to proceed with publication immediately.
And the effect on the public was?
Profound.
Yeah.
The American people finally got critical, fact-based information that the government had actively worked to keep from them. It completely shifted the public conversation about the Vietnam War and really fueled the anti-war movement.
Okay, so that's the history. But let's bring it to today. Why should you, listening to this now, care about a 50-year-old case about a war that ended decades ago?
Because this 1971 decision is the legal cornerstone for every single major leak controversy we see today. Think about the diplomatic cables released by WikiLeaks, or the huge intelligence leaks about government surveillance programs. Every single time a major news organization publishes classified information, despite loud warnings from the White House, they were standing on the legal ground that was established by the Pentagon Papers case.
So this ruling is what guarantees that if the government wants to stop a story from being published, they face that maximum level of scrutiny.
They do. They have to prove in a courtroom, not just in a secret briefing, that the threat is immediate and irreversible.
And you can actually see this in action.
Absolutely. Think about 2013, when news outlets were publishing all those details about massive surveillance programs. The government made a lot of noise, a lot of warnings about harm, but they never seriously tried to get a prior restraint.
Why not?
Because they knew they couldn't win. They knew from this case that the burden is just too heavy to meet unless you can prove that a disclosure will genuinely lead to immediate physical harm.
It really reinforced the role of the judiciary as a check on executive power. The court basically stopped the executive branch from using national security as a kind of blank check for secrecy.
It confirmed that in the American system, the default setting is transparency, not security, through silence. And that protection is maybe even more vital today, in an age of instant digital information and massive government data collection.
So to wrap up our deep dive, let's just state that core idea one last time.
The freedom of the press is protected by setting the bar for censorship at an almost impossible height. The government has to prove a grave, immediate, and irreparable harm.
And that leads us to a final, provocative thought for you to think about.
If the press serves the governed, not the governors, and if this high constitutional bar exists to make sure the public gets this kind of sensitive information, then what is the responsibility of that public? I mean, this case ensures the press can publish what the government tries to hide. But the real health of a democracy, that might rely on the public's willingness to actually process, to critically analyze, and then act responsibly on that challenging new knowledge.
You've been listening to The Daily Brief, one landmark court decision explained in plain English every day. Presented by FindCourtCases.com, this is your daily briefing on the law that shapes American life. Thanks for listening. We'll be back tomorrow with the next case.